Hey guys, I want to cover. Oops. Hey guys, real quick, I want to go through the steps of a trial. You guys are going to be going through this in our mock trial, so I want to make sure that we got this down before we move forward. First and foremost, we're going to start with the offense being committed. Now, whether this is a criminal charge or a civil suit, there's some offense that happens, right? That's the first thing that's going to happen in any case. Is somebody has to be wronged one way or the other. Right. Next thing you know is we're going to see a charge filed against an individual if it's a criminal case, or we're going to see a lawsuit filed against an individual corporation if it's a civil case. After that, what we'll see is the period of discovery. That's the next thing we're going to do. But the period of discovery is basically you get more than just the basic facts. You get the affidavits of the witnesses, you get the other side's ideas, you get all of that information given to you so that you can use it in preparing for the next step, which is going to trial. Now, a lot of cases actually don't make it to trial during the period of discovery or when the charges are filed. Sometimes a defendant or the defense team will say, you know what, let's settle this. Let's either have a plea deal where I agree that, yeah, I did it, but, this is kind of why I don't really need to go to court. We don't need to waste the time. Or we'll settle out of court. So famous, kind of lawsuits out of court would be the McDonald's coffee case where the lady spilled hot coffee on her lap. She settled out of court for an undisclosed amount of money. All right, trial. After the trial, we'll start with the opening statement. So during this period, we'll have an opening statement in which we see the prosecution leading off or the plaintiff leading off, describing their side of the case and what they're going to do. All right, and then we'll have the defense do it. After that, we'll do the plaintiff or prosecution's direct examinations of their witnesses, followed by the defense's cross-examination of the plaintiff witnesses. At this point, the prosecution or plaintiff will rest for a period of time until the closing statements. The defense then gets a chance to do its direct examination. The prosecution gets to cross-examine the defense witnesses, followed by our closing statements. So the prosecution will go first, defense will follow. After the prosecution, we'll see a rebuttal period for the prosecution, after the defense, we'll see a rebuttal period for the prosecution, followed by jury instructions. Now, if it's a civil case with a jury, the judge will instruct the jury, these are your options. If it's a criminal case, the judge will say, this is the legal definition of the crime. Beyond a reasonable doubt, is this person guilty? They'll go away for a little bit. The judge may step off the stand if he's got to make a decision, and then they'll reconvene the court for what's known as the verdict. All right, the verdict in a criminal case is going to be yes, guilty, not guilty. In a civil case, it's going to be liable, not liable, or liable, but whatever it might be. There's a lot of options there. After that, we will see sentencing or awarding of damages. So you're going to jail for a year, or hey, you just got $1 million, whatever it might be. The sentences, damages parts. Now, if we go through this and there's found to be an error or a disagreement or somebody else is willing to hear the case, we'll go to an appeal and repeat a lot of the process over again. So the offense is something committed by somebody or where somebody was wrong. So it could be something as simple as speeding. It could be something as complicated as murder. It could be even just breaking into somebody's car. All right, it could be you punching somebody else in the face where the court says it's not a crime, that's fine, but that person needs to sue in order to get that. So in our case that we're going to be looking at, it's the search of a student that was allegedly wrong, according to the plaintiff in our case. Next, we're going to see charges filed. All right, so the state's either going to charge the defendant with a formal crime, so whether it be murder or speeding, there is a charge there. All right. If you decide to bring the suit to court, you will bring about that wrong that occurred, and you will inform the other side that you plan on suing. All right. So at this point, either civil or criminal, you're going to see the party be made aware what is happening and the charges pending against them. Next, we'll have the period of discovery, and this is the next big thing that we're doing in class. And at this point, you will get the evidence from your side and the other side. So you will have a chance to kind of make it so that we know everything that's going to be taking place. All right, we'll begin the trial. Criminal case, we're going to have a jury. Civil case, jury could happen, but may not be involved depending on the circumstances. All right, opening statements is the first thing. Both sides have a chance to state what they plan to prove to the judge or jury. It is a roadmap. Think of your opening statement as an argumentative or persuasive essay. You open up, you have a strong thesis about the guilt or innocence of the person involved, or the liability or the non-liability of the person involved, and you lay out, this is how I'm going to prove it to you, okay? After that, we'll do some questioning, and we'll talk about questioning as we kind of go forward. The prosecution has a chance to lay out its case first, right? The defense can poke holes through the cross-examination, switch sides, all right? Well, actually, the prosecution can rebut those ideas. Next, the defense has a chance to do its direct examination. The prosecution has a chance to poke holes in the defense's theory, and then the defendant can have the rebuttal period as well. Go to our closing statements. This is a summary of the case. Summary, all right? Hey, my client's innocent because of this, this, and this, right? It is writing a persuasive essay with the evidence that you have presented. If you have not presented the evidence, it looks really, really, really bad in the eyes of a judge and jury if it comes out just during the closing statement. Okay? So the defense will give its closing statement at the end. The prosecution will have a chance for the final word. Why is that? I am not sure. It seems a little unfair. The last thing that the jury hears is from the prosecution, but that's the way our court system operates. Judge will instruct the jury as to what they can decide. Go and deliberate. Make your decision. All right? They'll provide the jury with the instructions, and then basically, if it's a criminal case, they'll remind them of the case law. Finally, a verdict is made by either the judge or the jury, and it's the decision of the court. We can appeal it until a higher court or until nobody wants to hear the appeal. Last but not least is the sentencing and damages. All right, sentencing happens after the case and after the verdict. Sentence is usually a jail or community service, whatever it might be. Damages could be awarded by a jury if it's a civil suit, all right, or they could just be found liable without having to pay damages, all right? Last but not least, we'll go to an appeal court. That appeal court may get it there. Most cases get one chance at an appeal, right? Death penalty cases, for some reason, take years upon years, all right? And pretty complicated thing, and there's a lot of people pushing one way or the other for those. Kind of a big thing there, but death sentence cases usually take quite a bit of time. If it's a constitutional case, all right, chances are you may be able to have it heard in the highest court in the United States, the Supreme Court of the United States, but only if it's a constitutional case. And sometimes they'll turn down constitutional cases, all right? A great example would be the gay marriage bans in certain states. When they were challenged, they went through the state courts, and the state courts said, hey, you know what? We can't decide that. That's not constitutional. And it went to the Supreme Court. Right now, the Supreme Court is kind of controlled by a more liberal plan. Liberals tend to support gay marriage. And what you saw this idea, the Supreme Court say, we're not going to hear that case right now. And that's kind of what they did. So it became this thing, and you had to continue push and push and push. It's actually a pretty interesting topic to follow if you guys have the time. Anyways, appreciate you listening. Thanks for watching. We'll see you again next time. Take care.